Meghan is a trained actress. What she does is that she studies people. She's not a good actress, but she is a trained one, right? She's been doing it her entire life. And there was no doubt that she studied Princess Diana. She studied her mannerisms towards Harry when he was a boy and the way that she grabs her face. And this is the psychopathic elements of what she does, putting a pregnancy text next to Princess Diana's hair, saying that she put her hands on the grave to have a conversation with her, bursting into tears. And she has convinced, there's a thing called in psychology called the Freudian transfer. She has convinced Harry that she is Princess Diana.
In the early hours of December 23, 2025, Buckingham Palace issued a statement that was precise, unambiguous, and final. After nearly 4 years of legal battles, appeals, and public dispute, Prince Harry's effort to reinstate taxpayer-funded police protection in the United Kingdom had failed completely. The Court of Appeal upheld its previous judgment, confirming that the Duke of Sussex would not be entitled to automatic state-funded security when returning to Britain. Within hours, the palace responded with unusual clarity. In a carefully calibrated intervention, King Charles III framed the ruling not as a personal loss for his younger son, but as a constitutional clarification the monarchy could no longer postpone. The decision, the statement said, brought necessary finality. It reaffirmed that royal status cannot exist independently of royal responsibility and that public resources must be governed by fairness, duty, and service to the nation. For the first time since the Duke and Duchess of Sussex stepped back from royal duties in 2020, the institution publicly articulated a principle long emphasized by critics and constitutional scholars alike. Royal privilege cannot endure when severed from royal obligation. The ruling marked the conclusion of a legal campaign Prince Harry launched in 2021 after the Home Office confirmed that his UK police protection would be assessed on a case-by-case basis following his departure as a working royal. Harry argued that the decision exposed his family to unacceptable risk and amounted to unequal treatment. The courts disagreed at every stage. On December 23, the Court of Appeal concluded that the government had acted lawfully, proportionately, and within established national security frameworks. Crucially, the judges reaffirmed that there is no automatic entitlement to taxpayer-funded protection for non-working members of the royal family, regardless of lineage or past service. The judgment explicitly dismissed claims of procedural impropriety and found no evidence that the royal household had interfered in judicial or security assessments, an allegation Harry has continued to raise publicly. The palace statement went beyond simply acknowledging the court's authority. It reframed the outcome as part of a broader institutional reset following years of reputational strain. For public trust to endure, the king declared, the crown must act with consistency and integrity. No individual, regardless of birth, could retain national privileges while declining national duty. The language was deliberate. After a decade defined by internal division, public confrontation, and the commercial exploitation of royal association overseas, the monarchy moved to reassert itself as a public institution, not a private inheritance.
When you have been lied about for a series of years, how hurtful that is.
Senior aides described the moment as the drawing of a necessary boundary. Not against a person, but against a precedent that threatened to erode the logic of constitutional monarchy itself. Yet, even as the legal process concluded, Prince Harry showed no sign of accepting the outcome. Speaking from California, he reiterated his belief that security concerns for his wife and young children justified continued state protection, regardless of his official status. He again implied, without presenting evidence, that palace influence had shaped the environment in which his appeal was assessed. To palace officials, this posture confirmed a long-standing concern that the Duke was seeking the protections of royalty without the constraints of service, while rejecting the accountability that accompanies both. Privately, officials noted that Harry's children have never returned to the United Kingdom in any royal capacity, nor has he proposed a framework under which his family would resume official duties. In this context, security has become not a prerequisite for service, but a substitute for it. At the core of the dispute lies a constitutional reality Harry's legal team was unable to overcome. The British monarchy is not simply a family legacy. It is a national institution supported by government authority and public funds. Police protection is not a ceremonial courtesy. It is a national security function funded by taxpayers and justified only by public interest. As the Home Office emphasized in court, extending such protection without a corresponding public role would undermine precedent and accountability alike. In this sense, the Court of Appeal's ruling aligned precisely with the palace's position to prevent the misuse, perceived or actual, of national resources for private or commercial ends. By midday on December 23rd, it was evident that this was not merely the end of a lawsuit. It was the formal closure of an era in which ambiguity allowed grievance to coexist with privilege. The monarchy, worn down by years of internal conflict, chose clarity. As one senior royal source put it bluntly, the institution cannot be asked to subsidize separation. If Buckingham Palace believed the ruling would close the chapter, Prince Harry's response ensured otherwise. Within hours of the judgment, sources close to the Duke confirmed that he regarded the outcome not as legal finality, but as a moral failure of the system, one he believes was shaped by forces beyond the courtroom. From California, Harry repeated his claim that the withdrawal of guaranteed police protection places his family at unacceptable risk, and that without it, a return to Britain, even for limited engagements, is impossible. What he did not outline was any concrete plan to resume royal duties or accept the institutional constraints such duties require. To palace officials, this omission was decisive. For the royal household, the dispute has long ceased to be about security logistics. Instead, it has become a case study in inverted logic. Traditionally, security follows service. In Harry's argument, service is postponed until security is restored. Senior aides described this as an untenable reversal, one that would allow a former working royal to negotiate public privilege from outside the institution without committing to its responsibilities. That inversion, they argue, explains why the legal campaign persisted despite repeated judicial defeats. The issue was never solely protection, it was leverage. Central to Harry's public narrative is the welfare of his children. Palace records, however, underscore a stark reality. His children have never returned to the UK in any royal capacity, nor have they been introduced to the institutional structures that define royal life. From the palace's perspective, the children's argument functions less as a logistical concern and more as a rhetorical shield, placing emotional pressure on the institution while avoiding reciprocal obligation. The absence of security is presented as the barrier, one senior courtier observed. Yet no plan has ever been submitted for service, representation, or even sustained presence. This contradiction is amplified by the Sussexes' commercial activities in the United States. Over recent years, Harry and Meghan have built media, publishing, and entertainment ventures that trade explicitly on royal identity while rejecting royal governance. To the palace, this dual posture, distance from duty combined with proximity to brand, has steadily eroded trust. Repeated warnings were issued privately. According to multiple sources, the couple was cautioned against blurring institutional credibility with personal monetization, particularly while national symbols and titles remained central to their public persona. Those warnings were acknowledged and disregarded. What frustrates senior royals most is not dissent, but delay. Palace officials believe Harry deliberately prolonged the conflict through litigation, appeals, and media interventions. Not to resolve it, but to keep it alive. Each extension sustained ambiguity. Each public statement reframed legal closure as personal injustice. Each allegation of interference, despite judicial rejection, fueled public mistrust. From the palace's perspective, this strategy is corrosive. It undermines the courts, destabilizes constitutional norms, and reintroduces private grievance into a public institution. Notably, senior figures have refused to engage publicly. Prince William, Princess Anne, Prince Edward, and Catherine have all maintained disciplined silence. According to palace insiders, this restraint is intentional. Authority, they believe, is preserved through process, not rebuttal. The court's judgment speaks louder than any counterstatement. Behind closed doors, the message was unequivocal. Privilege separated from service is not reform, it is erosion. By late evening on December 23rd, positions on both sides were unmistakable. The courts had ruled. The king had spoken. The government's stance aligned with both. Harry, however, remained unmoved, continuing to frame the outcome as persecution rather than precedent, and treating institutional boundaries as negotiable. For the palace, this confirmed a hard conclusion: reconciliation cannot occur where responsibility is refused. Behind the palace's composure and Harry's continued protest lies a legal architecture far more rigid than personal grievance allows. By the time the Court of Appeal issued its final ruling, the dispute had been stripped of sentiment and reduced to constitutional fundamentals: who qualifies for state-funded protection, on what basis, and under whose authority. The answer, the court made clear, does not turn on bloodline. Police protection funded by taxpayers is not a royal entitlement. It is a national security function administered by the Home Office and assessed by specialist bodies tasked with balancing risk, proportionality, and public interest. The court reaffirmed that the Royal and VIP Executive Committee operates within this framework as a mechanism of the state, not as an extension of the monarchy. Its mandate is to protect individuals only where a public role creates a public risk. In Prince Harry's case, that link no longer exists. Judges rejected the argument that Harry's former status created a permanent obligation. His decision to step back from royal duties constituted a material change in circumstances, lawfully justifying reassessment. The case-by-case model offered to him was found neither punitive nor discriminatory, but consistent with how the UK treats all non-working public figures. Claims that the royal household exerted improper influence were addressed directly. After reviewing classified and redacted material, the court found no evidence of unlawful interference. The presence of palace officials within advisory structures was consultative, not controlling. The government warned that restoring automatic protection would undermine precedent and invite claims from former officeholders and non-working royals alike, effectively transforming security into a portable privilege detached from public service. The judges agreed. King Charles III quietly aligned the monarchy with the court's logic. Palace sources say he viewed the ruling as a reinforcement of institutional discipline, protecting the crown from accusations of favoritism. After years of contested neutrality, he chose constitutional clarity over familial ambiguity. Perhaps the most consequential element of the ruling was its finality. By upholding Home Office discretion and rejecting procedural challenges, the Court of Appeal left no viable path forward. Any further appeal would require overturning the foundations of national security governance, an outcome legal analysts consider implausible. What began as a personal challenge in 2021 became, by December 2025, a binding public precedent. The courts drew a clear line between service and separation. The government insisted on accountability. The palace affirmed principle. In the days that followed, the monarchy consolidated authority through restraint. Princess Anne's influence was decisive, emphasizing that status is functional, not sentimental. Prince William embodied future leadership through silence. Prince Edward upheld policy uniformity. Catherine reinforced legitimacy through uninterrupted service. Together, they presented a unified doctrine: the crown is governed by rules, not relationships. Attention soon shifted west to California, where Harry and Meghan continued to frame the ruling as injustice rather than legal conclusion. Yet in Britain, public response suggested the palace's firmness had restored confidence. Clarity, not accommodation, stabilized legitimacy. By the close of December 23rd, the moment was defined. The court case was over. Policy was affirmed. Principle was articulated. This was not the expulsion of a son, but the reassertion of a standard. In modern Britain, the palace made clear, royal privilege ends where royal responsibility does.